Well, it depends. The hierarchy of authority that governs associations is you have the Florida statutes, then you have the Declaration of Condominium or Covenants, then you have the Articles of Incorporation, then you have the bylaws, and last but not least, you have the rules and regulations. Now, on the rules and regulations, those are issues that are to be voted on by a majority of the board members and not by the unit owners. Now, the question sometimes becomes, is that issue properly supposed to be disposed of in the rules and regulations, or is it something that needs to be put in the declaration, which would require an amendment, which would require member votes as opposed to board of director votes? Now, if it's something that is appropriate to be put in the rules and regulations, and the directors add those to the rules and regulations, those are enforceable regardless of whether or not the majority of the homeowners are in favor of those rules or not. So if it's an appropriate restriction to be placed in the rules as opposed to the declaration or in the bylaws, which would be a little more rare but could happen, if they're placed in the wrong place, then certainly those rules that would be put in could be successfully challenged. But if they are put appropriately in the rules and the regulations, and the meeting is properly noticed, and they follow the rules in regards to the notice of the meetings, and they have a proper meeting and a proper motion and a proper second, and a majority of the board votes on it, then they can keep adding rules and restrictions as long as those are supposed to be placed in that particular governing document.